This video will provide an introduction to statutory research. When conducting statutory research, it is helpful to have a basic understanding of the role statutory law plays in the U.S. legal system, as well as the publication process for statutes. First, let's discuss the role of statutory research in transactional practice. While the traditional law school curriculum tends to focus on case law, many transactional practice areas are primarily controlled by statutes on both the state and federal level. Some examples include banking and financial services, business entities, commercial law, securities, intellectual property, tax, and labor and employment. In those practice areas, the statutes will establish the rules with which the client must comply in carrying out their day-to-day business or in completing a transaction. The nature of the legislative process can also impact transactional clients. First, legislation is generally prospective in nature and will impact the rules going forward, which can have serious impacts on a client's business. So as a transactional lawyer, it's important to keep informed of legislation that may amend existing or create new laws impacting your practice area. Next, the legislative process is political, but it also allows for participation from the public and industry organizations. Clients may want to become involved in the process to shape the laws that will impact them. So being able to efficiently locate the controlling statutory authority, analyze it, and also to remain current on new and pending laws relevant to your practice area are critical skills for a transactional lawyer. Let's quickly review the source of statutory law and its interaction with other legal authorities. On the state and federal level, constitutions establish the system of government and define the powers of the three branches of government. Constitutions are the preeminent source of law in the United States, and all other law, including statutes, must comply with constitutional requirements. Each of the three levels of government are empowered to make law. Statutes are the laws created by the legislative branch. Where a statute exists, it will be the starting point for your legal research. The executive branch generates administrative law, which we will look at in more detail later in class. A statute may authorize the executive branch to create regulations which will contain more detailed and technical rules in a particular area. Finally, the judicial branch generates case law or common law by applying and interpreting statutes in order to resolve disputes brought before it by the parties. Therefore, when researching statutes, you will need to keep in mind that you may also need to look for regulations or case law in order to fully address a legal issue. When you are conducting statutory research, you will most likely be using a code. A code is a collection of laws arranged by topic. However, it's useful to understand the publication process for statutes. This process has its foundation in the print publication of statutes, and while much of legal research is conducted online now, the process still applies to the online publication of statutes. I find it helpful in understanding the publication process better if I remember it originated with print publication. When a law is first enacted, it is published as an individual standalone act called a slip law. On the federal level, they are published as the public laws. A public law is cited by the session of Congress, and here are examples of the Dodd-Frank Act. You can see it was passed in the 111th Congress, and then it will be followed by a number indicating that it was the 203rd Act passed during that session of Congress. Next, the law is published in a bound collection of slip laws arranged chronologically, known as session laws. At the federal level, they're published in the statutes at large. Here, our example of the Dodd-Frank Act indicates that the act was published in the 124th volume of the statutes at large, beginning on page 1376. Finally, and most useful to practitioners, the law is organized by subject matter and published in a code, along with all other laws currently in force. So laws that have been repealed or amended have been removed from the code. On the federal level, the code is published as the United States Code. And in our example, the Dodd-Frank Act, appears in the United States Code in Title 12, beginning at Section 5301 and following. In this screenshot, you can see the Dodd-Frank Act, first as published as a slip law, Public Law 111-203, then where it would be published in the Statutes at Large, Volume 124, and finally as published in the Code in Title 12, Banks and Banking. Our example was a federal law, but the publication process is the same on the state level. Most of your research will be conducted in codes as they contain only those laws currently in effect and are arranged by topic, making them easier to use and search. While the organization of codes may vary from state to state, in general they follow the same organization as the U.S. Code on the federal level. Generally, in codes, the statutes are broken down into broad subjects called titles. They're then divided into subtopics called chapters or subchapters, and then within each chapter there are numbered sections containing the actual text of the law. In this screenshot of the Dodd-Frank Act as it appeared in West's United States Code Annotated, you can see this hierarchy. It's located in Title 12, Banks and Banking. You can see it's located in Chapter 53, and then it's broken down into different subchapters, each containing sections with the text of the law. As I mentioned, codes exist on both the state and federal level. You will need to determine what jurisdiction applies as part of your initial research analysis. Depending on your jurisdiction, you may have a choice between codes. First, there may be an official code, which is the code published by the government. And there also may be an unofficial code, which is published by a commercial publisher. In some states, a commercial publisher may be designated as the publisher of the official code. Next, you may be able to choose between an unannotated or annotated code. The unannotated code is often the official code. Unannotated codes contain few editorial enhancements, while annotated codes include editorial enhancements such as prior versions of the statutes, references to secondary sources, and citations to and summaries of interpretive case law. On the federal level, the United States Code is the official version of the federal statutes, and the United States Code Annotated and the United States Code Service, published by Westlaw and Lexis respectively, are both the unofficial annotated codes. In practice, using an annotated code will provide many more resources to assist you with your research and your understanding of the statute. Here is a side-by-side comparison of a section of the Investment Company Act of 1940. On the left is the United States Code, the official unannotated version, and on the right is the same section from West's United States Code Annotated, an unofficial annotated version of the code. You can see that the official version provides some information on past amendments and effective dates, while the annotated version provides additional information such as notes of decision. Notes of decision are summaries written by West editors of cases interpreting or construing the statute. There's also a link to history. This provides you access to prior versions. There are also citing references. This would be any citing references, generally those references contained in a key site report. And finally, there's context and analysis, which is cite to secondary sources that may be helpful in explaining or applying the statute. So as you can see, the annotated version of the statute provides many more resources to assist with research. We have been looking at the structure and features of codes, the collection of all current statutes and subject matter. Now let's focus on the organization of an individual statute or law. Legislatures generally pass a statutory scheme, which is comprised of multiple sections, which then get included as a chapter or subchapter of a code. Keep in mind, every statute is unique. Some may be long and complex, like the Dodd-Frank Act we were looking at, while others will be short and straightforward. However, because the legislative process is for the most part a formalized process, Most statutes have a similar structure and follow a particular sequence. When you are working with a statute, you will first see the opening sections. The opening section will contain the title or name of the statute, the findings or purpose of the statute, as well as the scope. These sections can provide insight into situations in which the statute will apply, as well as the legislature's intent in enacting the statute. Most statutes also contain a definition section, usually included at the beginning. The definition section is very important in applying the statute. The next section includes the operative provisions, including the heart of a statute, the general rules, exceptions or exemptions from the rule, and finally, the consequences for not following the legal rules, which could include criminal sanctions, civil fines, or payment of damages. Many statutes also provide sections on how the statute will be enforced. The final sections of a statute may contain technical provisions, such as the effective date of the statute, as well as severability or savings provisions. This is the table of contents for the Investment Advisors Act of 1940. The opening sections contain the findings and definitions sections. Next follow the operative sections containing the rules for registration, prohibitions, and exemption. The implementation section follows, addressing enforcement and penalties. Finally, the technical sections follow, providing the effective date, rules of construction, and separability. In summary, statutory research is an important skill for transactional lawyers as statutes regulate many transactional practice areas. When researching statutes, you should also review and read the entire statutory scheme to understand and apply the law accurately. Statutes cannot be read alone. You must identify and review interpretive case law and relevant regulations to understand the entire body of law governing a particular area. Annotated statutes can be very helpful in researching statutes, as they will provide references to primary and secondary authority that can help you understand the statutory scheme and interpret individual sections. In our next video, we will examine the process of researching statutes in more detail.